it's your turn.
Okay, guys, I think we're back. For some reason, who knew? And I don't understand why we're not streaming and why it breaks like this, because it looks perfect on my computer. So, nevertheless, I want to just quickly ask James and Joe and Alvie to summarize again the decision on the MERS issue. I'll pull that up because I'm not sure where we lost live streaming. We'll do the MERS and then do the order of assignments, order of recordation. The assignments and trustee substitutions, do they have to be filed before or after the notice of default? Does it matter? So let's step back into the MERS issue. This is a question from someone that emailed me and said, he thinks there's a smoking gun because MERS is not licensed to do business in California and not registered with the state at the inception of his loan. So what do you guys have to say about that?
Well, if MERS is a beneficiary, I don't see why. If MERS is a lawful beneficiary as agent for the lender, then only the lender would need to be licensed. MERS wouldn't need to be licensed. Now, after that, it goes in the intangible world. Now you're getting under national laws. MERS wouldn't need to be licensed in California.
Right. So that's sort of a non-starter issue.
But this is where it helps to prove that there are two notes involved. The tangible note created by the homeowner and the intangible note created by the account debtor, who is also, in most situations, the originating lender.
Right. I had to think that through because, and again, I'm learning along with everybody about this. So now
You explained it out a little bit. CJ, if I want to kind of point this out to some people that may be able to understand it a little clearer.
Go.
Can you hear me?
Yes, go ahead.
Yes. Okay. Can you hear me?
Yes, this is Alvie, right?
Problems with my phone. Sorry about that. I think of people, it's kind of simple. If you go to public records and look at some of the power of attorneys that are sitting in there, for example, I've got one I pulled out of Williamson County from Wells Fargo Bank, that the power of attorney, it's a limited power of attorney that's about 38 pages long. It shows Wells Fargo Bank N.A. as a trustee grantee for the holders of various pooling and servicing agreements or trust servicing agreements that are recorded that these mortgages that homeowners have been put into trusts. So whenever it points to a pooling and servicing agreement, you might want to go to look at Article 2 in a pooling and servicing agreement and see the conveyances at the origination, and this could have happened before the homeowner even closed on the loan, that the originator through the sponsor endorsed, according to the pooling and servicing agreement, endorsed the note in blank over to the depositor. And from there, maybe it went to the sponsor as far as that goes. But yet it was endorsed in blank. And here in Texas, we've got one simple law, Texas Local Government Code 192.007. It says that any action relating to that instrument would be recorded. But the catch to that part is that it hadn't been recorded yet. That note's already been passed along, and then the originating lender, broker, whatever you want to call him, will go in and record that deed of trust in their name into it, but yet that the homeowner's borrower's note, that paper note, has already been endorsed in blank to someone else into the securitization and then traveling on. So if people can wrap their mind around understanding that, yeah, it's possible that they may be able to show up with that note, which I don't think so, according to even the Florida Bankers Association saying that they eliminate the paper after they scan everything. So your note, you look at 3203, 3303 in there for the transfers as far as that goes, the negotiability of that instrument. Were they able to do that after they registered it into a MERS system? Highly doubtful. Same way with the security instrument. How is it that they could take the security instrument and strip it from the paper note and use it to create a transferable record in the MERS system, and then take the value of the note and place that into the MERS system too? They just got rid of both those instruments by law, by operation of law is what they're basically doing. And so when they file that assignment into public records, what they're doing is they're trying to give the impression that they're reattaching that security instrument back to the paper note.
Right, and that gives them authority to do so.
Lawfully.
Right, right. And I agree with you. What you're saying is basically go to the statutes. That's why in my simple owner statement of suspicious documents, we've just quoted the law, because most people, like you said, haven't even read it. They don't even know what it is, where it is, what it says. And once you read it, it's really pretty powerful. And stop playing their mind games. Let's move into the laws and how they violated these laws. Here's another question. They're saying, this writer writes in and says, my house was fraudulently repossessed in a trustee sale in August 2012. So what rights do they have? I mean, now that house is being listed and it's being sold, and they've already paid an attorney to file a, quote, breach of contract and wrongful foreclosure complaint. Is that what they should have done? What do you guys think?
Well, okay, I didn't follow what happened.
Well,
What I might chime in on that part is that, first of all, we've got to educate the people that we elected, because apparently we know more than they do.
Oh, absolutely.
That's the problem. We're not going to get very far, no matter how much we cite these laws to them, because of their ignorance. And I say this because of my past experience here dealing with local officials or whoever it is, that they really don't understand or comprehend what's going on. They think that they're still doing things the old paper way.
Right.
They don't understand that there's an electronic problem here, and so until we can get those people educated and all, it's going to be very difficult for anyone, because after all, we're just a deadbeat homeowner. We're not a bank or a representative from a bank saying we're saying everything's right, and they may lead to believe them with that, and that's what they've done whenever they never divulged or disclosed exactly what mortgage that they were talking about when they were in that courtroom. They just say mortgage, and the judge assumes they're talking about a paper mortgage.
Correct, and also the fact that the presumption of